We just started the recording, so I'm glad to welcome you at our seventh, I believe already, lecture of ITC Leiden Alumni. Today we are especially lucky to have Mrs. Alina Guseynova, our Ukrainian speaker, who graduated from Leiden. In which year, Alina? It was. You look so young.
It was
I'm scared
already a long time ago. It was 2011.
2011.
Oh, it's anniversary this year. It's 10 years.
Okay. And just a few words about Alina. Alina is an independent international tax advisor. She has over 13 years of experience in corporate transaction, personal international tax structuring. Alina organized amazing program or study, short-term study of professor case given by Professor Kees van Raat in Kiev in Ukraine. Besides perfect organizational skills, Alina worked for Deloitte for over 10 years in Ukraine and Belgium, and she has clients from 78 jurisdictions. We just touched upon the year of graduation, so basically 10 years of practical experience after graduation from Leiden. And Alina runs a very useful Telegram channel, Taxatic. I'm a big fan of this channel, so I'm read the news, excellent reviews of various court cases. And today we're going to speak about information exchange. So Alina is going to give a few examples how the related to information exchange cases are being decided by various courts in Australia, in other jurisdictions. We will do some voting, so please take a close look at what is happening on the screen because we will ask some questions. And well, that's pretty long introduction. So Alina, the floor is yours. Please go ahead.
Thank you, Rustam, for your introduction and for this opportunity to present here before the audience of international tax gurus. I have decided that it would be useful to start my story with a historical background. Then we'll slowly move to the types of information exchange and to their legal basis. And as chair and top, I will touch upon the real-life court cases concerning this area, and will summarize the useful tips for those of you who will be involved in the international exchange process on the side of the taxpayer. So I will now start sharing my screen. Just a moment. So as Winston Churchill was working to form the United Nations after the Second World War, he famously said, "Never let a good crisis go to waste." It was 2009. The world was in the middle of the worst economic crisis most people have ever seen. The economy had declined, banks, investment companies, they were going bankrupt, businesses were in huge trouble, people were losing their jobs, their homes. Slower economic growth meant lower tax revenues for governments. At the same time, the demand for social services was significantly high. So the governments were under pressure. They needed to make up for the lost revenues and somehow restore trust in the financial system. The situation intensified because of the scandals of 2008, when the Swiss banks were accused in assisting their wealthy clients to hide money from the tax authorities. That year, the UK was the chair of the G20 meeting, and as they discussed various issues, including the future role of IMF, and the World Bank, recapitalization of the banks, creation of the additional stimulus for the global economy, the cornerstone of everything was the lack of tax revenues and the increase in social spending. So that money had to come from somewhere. and that somewhere was mostly surrounded by the warm waters and enjoying summer all the year round. As you might also know, the main slogan for the American revolutionists was "no tax without representation." Well, in this situation, we can say that there is no tax without information. Most of the economists tax their residents on the worldwide income based on the self-assessment principle, meaning that the tax liability is based on the information on income received from the taxpayer. And if the domestic income is more or less possible to trace with the cross-border income, the story is a way more different. According to Gordon Brown, the UK Prime Minister at that time, it was mainly the President of France, Nicolas Sarkozy, who pushed through the question of exchange of information for tax purposes. In fact, he threatened to walk out of the summit room if his demands to tighten the financial regulation were not met. He was quite unpopular back then in France, and the country was occupied with protests. So President Sarkozy announced himself as a pioneer of the moral capitalism, appealing to traditional anti-capitalism feelings of France and blaming the crisis on Anglo-Saxons. But G20 refused to take the full mandate for this action and nominated OECD to do the job. So this is the beginning of the Global Tax Forum and the exchange of information in its modern view. Of course, the exchange of information existed before 2009. The first conventions on exchange of information were concluded by Belgium back in the middle of the 19th century with France and then with the Netherlands, and they concerned the information regarding inheritance matters. But this process did not develop much in the next 100 years, notwithstanding the adoption of the first double tax treaties. Firstly, there were not many that cross-border transactions at that time and taxes in general for the exchange of information. And secondly, the first half of the 20th century, the world was busy participating in the First and then the Second World War, and then rebuilding economies afterwards. Plus, there was little interdependence between the national economies and little trust between the countries. It was not until the 80s that the fact that the tax is global and that it relates to the financial system ended on the political agenda in various countries. This also coincided with the global crisis of 1973, 1981, and the lost decade in Latin America. And gradually, we arrived to J20 meeting of 2009, when the real actions followed to make the tax world more transparent. There are various, and by the way, on this slide, for those of you who are interested in art, I've managed to draw the line between the history of art movements and the history of exchange of information. You can see here surrealism, graffiti in 1980s, and in 2009, this is installation. Well, back to exchange of information. There are various types of exchange of information and collaboration between tax authorities nowadays. The oldest means is the exchange of information on request that became the first international standard in 2009. The standard allows tax authorities to make specific requests of foreseeably relevant information to other tax authorities for carrying out the provisions of the tax convention or for the administration or enforcement of domestic laws of the requesting country. Provisions concerning the exchange of information have existed in tax treaties before 2009. Article 26 of OECD Model Tax Convention and the Multilateral Convention of on mutual administrative assistance in tax matters supported all forms of exchange of information, including on request, spontaneous, automatic. However, a number of tax havens neither had any obligations on entities to keep the information, nor could they exchange that information. Just to stress, it is not only the question of getting the information from the tax haven, it is making them actually store that data, collect and then store that data from the taxpayers on a regular basis. Because if you do not collect some information like financial statements or beneficial owner data from the taxpayers, you have nothing to exchange with. As simple as that. The Global Forum enabled many European countries to conclude treaties on exchange of information with tax havens. To do that, the country had to be reviewed by the peer countries. The process is undertaken in two phases. Phase one reviews the assess of the quality of jurisdictions' legal and regulatory framework for exchange of information, while phase two reviews practical implementation framework. For example, in case of Ukraine, which joined the Global Tax Forum back in 2013, it was just a couple of weeks ago that it has been reviewed for the second time for phase one, and it got recommendations to improve the legislation. But Ukraine will only receive her rating after the phase two is completed. As far as I know, there are also 3 treaties under negotiation on exchange of information under negotiation by Ukraine with tax havens. This is Belize, the Cayman Islands, and Antigua and Barbuda. So the next type of information is automatic. While the Global Forum was busy implementing the exchange of information on request standard, there was an increased demand to raise the bar and to make automatic exchange of information the new global standard. At the beginning of February 14th, 2014, the OECD Committee on Fiscal Affairs published the 2 documents supporting the automatic exchange of information that was endorsed by J20 meeting. It was the Model Competent Authority Agreement and Common Reporting Standard, or CRS, as we know it. The CRS for the automatic exchange of information, of financial information in tax matters, was developed by the OECD with J20 countries and represented the international consensus on the automatic exchange on a reciprocal basis. The CRS and the due diligence of financial account information set out the data to be exchanged. The financial institutions required to report and the different types of taxpayers and accounts covered, as well as common due diligence procedures to be followed by financial institutions in identifying the accounts. The CRS draws extensively on the intergovernmental approach to implementing the US Foreign Account Tax Compliance Act, or FATCA, or as my teacher back in Leiden used to say, FATCAT, a US legislation seeking information on US citizens and entities holding accounts with financial institutions in foreign countries. FATCA generally requires that foreign financial institutions and certain other non-financial entities report on the foreign assets held by their US account holders or be subject to withholding tax. The US persons are also required to report their foreign financial accounts and foreign assets, the value of which exceed $50,000. Well, bigger thresholds exist for Americans living abroad and for married couples in the US. Foreign financial institutions that do not comply with FATCA will have a 30% withholding tax from any payment made to them from the US source. There is lots of critics around FATCA. Some businesses call the initiative imperialist. Just think about it. FATCA is imposed on entities over which the United States does not have any jurisdiction. This makes FATCA arguably the most aggressive extraterritorial enforcement of one country's tax law in history. It also impacted a lot the Americans living abroad and triggered a new wave of US citizenship renunciation. Because due to high compliance costs of FATCA for foreign banks, it was cheaper and more beneficial for them to close the accounts of their clients with US passports and green card holders. There are also practical problems associated with the automatic matching of data received with the available taxpayer data in the jurisdiction using IT tools. For example, issue arises when the tax ID numbers are unavailable, or the names and addresses cannot be matched, or jurisdiction uses different tax ID number, as for example, a permanent account in India. The FATCA and CRS obligations require the financial institutions to get self-certifications from account holders. But practical implementation and getting the correct data can also be a challenge. Furthermore, the FATCA and the CRS models, in my view, they need to be better aligned. The US has not yet committed to the automatic exchange of information standard, choosing instead to base its data exchange relationships on FATCA. The requirements of the CRS and FATCA differ in some aspects, and this puts an additional compliance burden on governments and financial institutions. For example, FATCA carves out charities out of the compliance and has the de minimis limit that I told you about, $50,000. CRS doesn't offer any exemptions for charities and doesn't have any minimal threshold, only for the accounts existing before 2015. CRS also does not have any penalties on the global level, as the legislation is incorporated in the local law and non-compliance becomes a local offense. Other types of exchange of information, they include spontaneous exchange of information, which I will cover in the real life case section, and such types of cooperation as simultaneous tax examination program, joint audits, and criminal investigation programs, and others. These do not happen often, and they're rather costly for the tax authorities to launch. But as far as I know, the mutual collection assistance program, it's still quite popular in the relations between USA and Canada. And here is the example of the information that could be received by the local tax authorities under the exchange of information programs. As you can see, this is basically all the personal data, personal information that the tax authorities could use to assess additional tax liabilities. On this slide, I have summarized the legal basis for various types of information exchange for tax purposes. They include the bilateral and multilateral documents. Some of the, some of the agreements, they are not, you do not see them quite often. For example, this mutual legal assistance treaties. As far as I know, there are only 19 of them for the US, and for other countries even less. But still, they allow tax authorities and also criminal agencies receive the information, the personal data on their residents from abroad. Um, Article 26 of OECD Model Convention governs all types of information exchange between the tax authorities. On this slide, you can see the 2017 version of this article. I highlighted with the yellow the later changes to this article, which happened in 2014. But most of the treaties are concluded earlier based on the earlier models of OECD Convention. I will briefly touch upon the major words in this article so that you knew how to use it in future. Paragraph 1 of article tells about the right of the competent authorities to exchange the information that is foreseeably relevant. The information in this case covers facts, including legal relationships about specific taxpayer, but also it encompasses non-specific information related to tax administration in general, for example, risk analysis techniques or tax avoidance schemes. The word exchange, it doesn't require that information be only transmitted when it is received from the other state. And you can easily interpret this word as supply of information. The term foreseeably relevant, very important one, it provides for exchange of information to the widest possible extent. They replaced in 2004 a term necessary, was sometimes interpreted in a rather absolute way, that is preventing a state from exchanging information if without the information proper and correct taxation could not take place. However, also under the term of foreseeably relevant, disputes cannot be excluded because it sounds rather vague. However, the commentary says that the so-called fishing expeditions of the tax authorities, they are specifically excluded from the scope of Article 26. And note that the exchange of information is not restricted to the taxes within the scope of the convention, and could include, for example, indirect taxes like VAT and customs duties. Paragraph of this article is all about confidentiality. Any information received under paragraph 1 by the contracting state shall be treated as secret in that state in accordance with the receiving state domestic secrecy laws. The secrecy law of the sending state, even if more stringent, is of no relevance here. Thus, the states should, during the treaty negotiations, consider whether the secrecy laws of the other state are acceptable. Information may only be disclosed to persons or authorities dealing with a specific tax law issue, such as the taxpayer himself, or other concerned with the assessment, collection, enforcement, or prosecution. The 2014 edition allows the information to be used for other purposes, such as prosecution in non-fiscal crimes, but only if the laws of both states allow to do so. Article paragraph 3 for paragraph 3 is the exceptions. It contains 4 exceptions when the requested state is not obliged to exchange information. For example, the requested state is of no obligations to carry out the administrative procedures that are not permitted under the laws of that state. It is also not obliged to exchange the information which is not obtainable under the laws in the normal course of administration. Apart from these written exceptions, a state may, for example, refuse to exchange information if concrete indications exist that secrecy, as required by the convention, will not be ensured by the receiving state. Paragraph 3 is not written as an absolute list of exceptions. The requesting state exchange information in cases which fall under the exceptions and is not forbidden to do so. Paragraph 3 may be evoked where the interest of taxpayers weighted against the interest of the interested state. The exception of the public order that you can see in the provision C is relevant in rare cases, such as the request which is motivated by racial or religious persecution. The public policy exception also aims at protecting the vital interests of the requested state, such as the national defense industry. Information held by Secret Service may also fall under this exception. Paragraph 4 is the exception to the exception. In other words, it warns the requested state about the situation when it cannot evoke the exception clause. For example, the requested state is required to collect information requested in the same way as if its own taxation was involved, and though it may not need the information for its own tax purposes. In other words, the effective exchange of information cannot be hindered because of the requested state's lack of interest in that information. Moreover, the state cannot refuse to exchange information solely because the information is held by the bank, other financial institution, nominees, or persons acting in an agency or fiduciary capacity, or because the information request is ownership information. That, however, that will be the case if domestic law would define the information held by the fiduciary or agent as a professional secret. Agent, well, you can see the term agency. Agency is to be interpreted in the broadest sense, and it includes all forms of corporate service providers, trust companies, lawyers, registered agents, etc. Turning to the practical part of this presentation, I would like to touch upon the selection of court cases from various countries. Most of them deal with the legitimacy of the information transfer from the source country, and I have chosen, I think, the most interesting ones. The first two questions or cases, they refer to the question whether the Treaty on Exchange of Information has been breached. Just to remind you that
just organizational remark,
yeah.
We are going to do some voting, right? So after you discuss particular case, there will be
Yes.
option to do to indicate what is your expectation in respect of who should have won this case, either tax authorities or taxpayer. So we have several such cases when, Alina, you are ready to launch this questionnaire. Paul, just tell me, so I will switch on the board and there will be option to vote whether you think taxpayer won or tax authorities won.
Yeah, Rustam, please, you will launch, because I don't know how.
Yeah, sure. Just let me know when it's necessary.
Yeah, I will let you know. Thank you. So now I will talk about two cases. They're connected. We can vote after the first and after the second one as well. And where I stopped? Okay, they refer to whether the treaty on exchange of information was breached, and I wanted to remind you that this type of bilateral treaty is the exchange of information on request. So the first case is from Cayman Islands. Project Wickenby was a long-running joint agency investigation initiated by the Australian government back in 2005 to combat offshore tax evasion. The investigation was jointly run by the Australian Tax Office, by the police, by the Securities Committee, by Crime Commission, I think. So a lot of parties were involved, and it was quite effective because it was concluded on the 30th of June 2015, after 76 people were charged and 46 convictions recorded. And according to the Australian tax authorities, Project Weekenby was responsible for recouping around 1 billion Australian dollars in taxes. Pretty impressive. Well, in terms of this project, the Australian Tax Office, or I will call it ATO, made 4 requests to the Cayman Islands tax authorities in 2011-2012, which were fully satisfied. The requests were made based on the Treaty on Exchange of Information concluded between the countries. However, the taxpayer was not informed, was not notified about the exchange of information, and the taxpayer argued the legitimacy of provision of such information to the from the Cayman Islands to the ATO. Because in the view of the taxpayer, the Cayman Islands tax authorities released the information ultra vires, so exceeding their rights, and the documents therefore were obtained unlawfully. So that was the question to the court. And who do you think won the case? Rustam, you can launch your voting.
We're just to launch it. So sorry, that's not the right one. Case number 1. So please tell us who should you think win this case? So 56% of the colleagues who took part in this question, or 62% for taxpayer. Tax authorities are losing with only 36%. So if we would be deciding cases on information exchange, this would be our judgment. Taxpayer should have won.
And this is correct. Because the Grand Court of because the Grand Court held that the release of information by the Cayman Islands to the ATO was unlawful, and ordered the local tax authorities to submit the request to the ATO to return the information and documents in dispute, and to put a stop to use or disclose of the information in proceedings.
Mm-hmm. Okay.
And
just practical wise, Australian tax office, most likely they should do this further investigation within Australia. So what is the relevance of Cayman court? So would Australian tax authorities listen to Cayman court?
Yes, and this is the next connected case where the information received by the tax authorities would be used in the court proceedings. And the question would be whether it can be used, because it was received unlawfully according to the Cayman Islands court.
Okay, good. Interesting.
And here the interesting part was that the Australian authorities also shared the information with the UK. So there was even third party involved in the bilateral treaty on exchange of information.
Mm-hmm, mm-hmm. Okay.
So the connected case from Australia, background, several companies have been subject to tax investigation in terms of Project Weekenby with regard to their activities in purchasing and selling listed Australian securities. Assessment of the companies had led to substantial amounts of additional tax penalty, charges, and interest due by the individual companies in the years from 2002 to 2007. In the case at hand, with the reliance of the evidence brought to the court by the ATO, which supported that the Australian individual tax resident was the beneficial owner of the Cayman Islands entities. The information had been provided by the Cayman Islands tax authorities based on the 4 information requests we discussed before. So the issue was whether the ATO can rely on the information received from the tax authorities in the Cayman Islands, because the exchange which had in the violation of the Cayman Islands domestic law, yes, it was basically illegal. So what do you think happened next? Who won this case?
Okay, so let's do another vote in case number 2. Now it is 50-50. Oh, it's changing quickly, so it's really
50-50.
Okay, so we have 3/4 of attendees believe that tax authorities should prevail in this case, and 30% are in favor of taxpayer.
Okay, so we have people who do not believe in justice here, and they're true. The tax authorities won the case. Well, in short, the court said that there is no breach of the Treaty on Exchange of Information, and that the breach of Cayman Island domestic law was less important than the public interest in revealing the true nature of the taxpayers' affairs being established.
Yeah.
So this case reveals really the significant lack of justice in the international exchange of information in situations where information is received unlawfully, but is nevertheless used further in the requesting state. And I agree with the view that the requesting state should not use the exchange information if a judge in the requested state has ruled that such information was unlawfully exchanged. In fact, some of the treaties on exchange of information provide for cancellation of exchange in such cases. Well, but in general, it must be something more common, and there must be a provision in the applicable agreement prohibiting the use of unlawfully obtained information in the requested state. What would you think, Rustam?
Well,
do you agree with that?
Well, if I look at what is happening in the world, we just had a recently conversation on this subject. The public becomes hysterical when it comes to well, so-called wealthy crooks who underpay taxes. And if we look at OECD, the rhetorics recently, I was especially surprised by statement like in the US we have to increase taxes and it is unfair that the workers pay their fair share of revenue. Maybe it's true to some extent, because if I look at Apple paying 0.5% corporate income tax on their gadgets, well, that doesn't match well with the 20-30% tax paid by, well, average workers. And nowadays, yeah, the public opinion is definitely in favor of penalizing people who underpay taxes, even at the expense of procedural rights, procedural well, compliance with rule of law, etc. So,
exactly, yes. But I still think that you have to respect the laws of the other state and the courts there. Well, the next, my next case is about the spontaneous exchange of information. the legal basis for which you can find in the bilateral double tax treaty, Article 26. So the taxpayer was a German partnership. For many years, it carried out the loan account for X, who was the daughter of the founder of the partnership. And a considerable amount of interest was credited to her. It was from 1993 till 2001. It was around 2.5 million Deutschmarks at that time. So X was born in 1965, and in 1989 she went to USA to study. At the end of 1995, she married a US citizen, and she believed that her immigration status during her studying exempted her from the US taxation, and she did not file any US tax returns before 1996. In 2005, she decided to inform the German tax authorities that she had paid tax on the interest received from the partnership starting 1995 in the USA. And that amount, a difference of $7,500 was due to currency exchange. The German tax authorities decided to share the received information with the US colleagues by spontaneous information exchange. And they sent the information regarding the amount of interest from the loan for the whole period from 1993 till 2001. The double tax treaty between Germany and the USA at that time had an old version of Article 26 on exchange of information and provided that the competent authorities of the contracting state shall exchange such information as is necessary for carrying out the provisions of the convention. So the taxpayer argued whether it was indeed necessary to share that information and to do the spontaneous exchange.
Okay, let's see what our
The
esteemed
voting, yeah.
attendees think on this case.
So who won?
Well, we believe tax authorities won. 70% of us believe that tax authorities won.
Well, you're partially correct, because it was in favor of both the tax authorities and the taxpayer. It was partially them, because the court held that the facts concerned were subject to tax secrecy under German law, and that the partnership was therefore entitled to an injunction unless the exchange was allowed under Article 26 of the tax treaty. And the court held that the transmission of the information was necessary as far as the years 1993 and 1994 were concerned. It was not clear whether X was a resident of the United States and in fact subject to tax in the United States in those years on the interest received, but there was a possibility that she was, and this was sufficient to consider the transmission of the information necessary. It was not the task of German competent authority to explore the details of the US tax law. Furthermore, one could not exclude that the US tax administration did not know the facts, as no tax returns had been filed for the years concerned. Remember, I told you no taxation without information. It was not the task of the German competent authority to establish that the US tax had in fact been evaded. With respect to the years 1995 through 2001, the court held that the transmission of data was not necessary because there were no serious doubts that the US tax administration knew about the payments because she submitted the tax returns. The next case is also dealing with exchange of information on request based on the double tax treaty. It is from Switzerland, and the case concerns the request of information sent by the Indian tax authorities to Switzerland. The request was based on the Article 26 of Switzerland-India Tax Treaty and sent for the purpose of obtaining information with regard to a married couple and their son who were subject to tax investigation in India. They requested information covered tax years 1996 to 2014. And the India tax authorities requested information regarding the bank accounts that had been opened by the tax authorities in the bank in Switzerland and the transactions carried out on that account. The Indian tax authorities further explained in detail that during an investigation at the home of taxpayers in India, documents had been found indicating that the taxpayers held undeclared bank accounts with the HSBC Bank in Geneva. Subsequently, based on information requested from the US tax authorities, it became clear that the taxpayers owned undeclared HSBC accounts in Switzerland. The information requested from Switzerland was required to determine the tax liability in India for this married couple and their son. The Swiss tax authorities, they requested further details regarding the underlying investigation. In a response, the Indian tax authorities explained that the information request was based on the independent evidence obtained during the domicile search. The searches had been ordered after important evidence of tax fraud had been obtained from multiple sources. The Swiss tax authorities obtained the requested information from the Swiss bank, informed the taxpayers of their intention to share the information, and effectively shared it. Shortly after, the taxpayers brought an action to the court to request the annulment of the decision to exchange the information. They argued inter alia that the request was illegal due to the extent that it was based on the information that was stolen from the HSBC branch in Geneva, and that the exchange would entail a violation of the Swiss Information Protection Act, which prohibited data exchanges with the countries that did not assure the adequate protection of human rights and which could lead to a serious threat of the integrity of their persons. But a little bit more background for you. Here's what happened. The bank account of this Indian family opened at HSBC branch in Geneva appeared in a so-called Lagarde list. This is the list of foreign residence accounts opened at the Geneva branch, which was stolen by the IT engineer of this bank, Evre Falciani, and transferred to Christine Lagarde, who was then the Minister of Finance in France. France, in its turn, exchanged this information with India. And India started the investigation regarding tax avoidance of these individuals, and as part of the procedures, performed a domicile search at that family house. During this search, they found the documents evidencing the opening of the bank accounts at HSBC Geneva. So the taxpayer argued whether the information requested from the information request from the Indian tax authorities was illegal to the extent that it was based on the stolen data, and whether the Data Protection Act was breached because India is one of the countries that do not respect the fundamental rights of its citizens. So wanted to know that this case could perfectly happen in Ukraine for the Ukrainian taxpayer, and the allegations towards the failure to respect the fundamental rights of citizens could be unfortunately also true in our case. So who do you think won this case?
So let's try to predict the response of Swiss court.
Yeah, it looks like a scenario for the movie, this one.
Indian movie. I believe Indian version of this movie and Swiss version of this movie might have different ending.
With a lot of dance. Yeah. And a lot of relatives found in between.
Yeah. So 50-50. So we really
50-50. Okay. Well, okay, 51. It was in favor of the tax authorities. I actually expected from Switzerland the other way around, that it would be more on the side of the taxpayer. But well, the court observed that the Swiss tax authorities were acting correctly when only exchanging information regarding tax years 2011 to 2014, because remember, the India asked for information starting in 1997. Because the double tax treaty covered only the tax periods starting 2011. With regard to the taxpayers' arguments that the information request was based on the stolen data, the court observed that in prior decisions, it had already been held that a state that was requesting information from Switzerland based on data stolen in Switzerland did not in itself constitute an infringement of the good faith principle of public international law. And furthermore, in the case at hand, the requested state had apparently received the information that was stolen pursuant to an exchange of information procedure with France, and India did not obtain that information directly from the person who had stolen the information in Switzerland. And the next argument regarding the good faith principle was, I think, brilliant, because the question was whether India had previously given assurance to Switzerland that it would not use the stolen data to send information requests. Such assurance had not been given. As such, the good faith principle did not prevent Switzerland from exchanging the requested information. With regard to the alleged violation of the Swiss Data Protection Act, the court observed that the taxpayers argued that their fundamental rights had been violated by the brutal house searches during the tax investigation, and that they did numerous threats afterwards. The court observed that reports issued by organizations like Amnesty International did indicate that public forces in India had been witnessed using torture during investigations. In some prior decisions, the Swiss Federal Supreme Court had categorized the states in 3 classes in that regard. The first category comprised of the states that respected the human rights. The second category were states where violations were a real possibility, but violations could be prevented by requesting the state to give diplomatic guarantees regarding specific issues. And the third category were states in which violations of fundamental rights were common and difficult to prevent. The court observed that India pertained to the second category, and that it was for the court to consider whether the taxpayers' rights were breached. So the court observed that there was little proof submitted to support their allegations. And based on that, the decision was in the favor of the tax authorities. Based on the case law available, I've made some following useful observations that you could use if you become engaged in the information exchange process. Well, first of all, always check the domestic law of the source of information state for data protection, confidentiality, trade, business secrecy clauses, etc., and go to the local court if any of these laws were violated and the receiving state has actually obtained the information illegally. Then you have to check whether there were the restrictions to exchange the information with the state violating human rights. Then I would also advise to check the procedures, whether they were followed. For example, the tax periods that were requested to cover, whether they are covered by the respective treaty, or whether the state would like to receive the information that was far beyond the period when the treaty became effective. Then also, in some of the court cases, I have seen that the information requests are sent not by the competent authority, but just by the, for example, local tax authorities that are not authorized to send such requests. And so in this case, even the sending of the request is already illegal, and the requested state is not obliged to reply to it. Then the domestic laws of the receiving state should also be checked for data protection, and where the information will go further. And remember that the old treaties, they may not allow to use the information in non-tax investigations or court proceedings. But even the new treaty, even in the new treaty, this information could be used in non-tax cases, but only if the law of both states allow only this information to be used. So this is also quite difficult to reach. Then also analyze what were the grounds for the information request, whether like with India, that was the stolen data that was involved, and also whether the tax authorities received that stolen data directly. Because in that case, if in the previous one, if the stolen data was received directly by India from Mr. Palsiani, I think that the outcome could be completely different of the case. Then also remember that the taxpayer has a right to receive the copy of the information request sent to the tax authorities, and also the request sent to the bank. Also, in some of the states, the taxpayer has to be informed by law regarding the request. So if you are not informed, the procedure again has been violated. And also check whether any discrimination was involved. Just see the Article 24 of the convention. For example, whether the rights of resident versus non-resident, or citizen versus non-citizen were violated in some aspect, and then you can also bring that further to court. So that was basically everything I wanted to cover today, and thank you everyone who has listened, and I'm open to your questions now.
We have a couple of questions which have been already asked during the presentation. Well, one of the, it's very easy. Why is independent consultancy, and what is a native language? I don't know. Should we skip this, or should we take it seriously, Alina?
Oh, this is question regarding me. Okay. I was expecting questions regarding information exchange. Okay.
Oh, we can skip. I just read out
loud.
No,
but my native language is Ukrainian and Russian, and well, also know English and some French. Oh. And I chose independent consultancy just because it was for me it was a nice continue career after Big Four, to try something new, something what I can do myself, and to become more flexible while doing what I used to do for 10 years in Big Four.
Okay. Well, this is anonymous question, so we don't really know who was asking this, but in Ukraine and Russia, it's not uncommon to just run your own practice. So it's really personal choice how you would like to arrange your affairs. But Alina's case proves that it's possible to be very much involved in international taxation question without being really affiliated to one of the bigger brands. So it's a free country, so you can do it.
Indeed.
Good. Any country exists that refuses to make exchange with information today?
Well, there are countries that are still not have not undergone any phases of peer review conducted in terms of the international exchange, international global tax forum and international exchange on request. As far as I remember, this is Maldives and some other not very famous. I don't remember, but some countries which are really not that on the list even of the famous tax havens. All the famous tax haven territories are already in that list, and they already have conducted were subject to peer reviews and signed a lot of bilateral tax treaties on exchange of information.
Yeah. Well, maybe there are some countries of which we are not aware of. So maybe there are some remote islands where people have no idea that
probably yes.
Information exchange, etc. But most of the countries they are covered for more than 10 years by this process. So it would be very difficult to find some real reliable country with some legal order which would refuse to exchange information. Although not every country is prepared to give anything, they will also make some decision, some judgment whether.
Indeed, but even if you find such country that doesn't exchange information, it might be really difficult to incorporate it in your structure, that entity in that country, because either the bank account would not be opened or possible to open at all, or other jurisdictions that you have legal entities in would require lots of information from you. Why are you situated there? What is your interest? What is your substance? So it's really, I think that the tax transparency is already there, so it's really difficult to hide.
Okay, good. One more question. US does not provide information to other countries. Is this correct or not correct? Tricky.
Well, yeah, US is not a part of CRS, yes, but it can provide information on request. So it doesn't provide the automatic exchange of information. It's not part of that, but it can. You can receive the information based on request, based on your bilateral tax treaty, Article 26.
Yeah. So there is a rather comment, and then the question: international law can't force every country in the world to respond for the request of information from taxation authorities. That's right. And one more question: what do you think will CRS influence middle or rich people like IT guys with startups? CRS. Well, it's interesting to hear your response to this.
The influence of CRS on IT guys.
Well, my version of this question, I was not asked, but well, just happened to be around. There is no particular exclusion for IT guys from CRS, and most of the banks, there are some thresholds, there are some safe harbors, but it's just difficult for banks to apply all these exemptions. So they just give everything to Minister of Finance, Minister and gives everything to just sorts out between the countries. That's pretty much it. That's my understanding how CRS works.
Yes, well, I think that it's okay. That's also the matter of how you use this information, because the country of residency of that IT guys, who I know currently quite often change their tax residency from Ukrainian to other countries. So that's a matter then of the receiving country of their new tax residency country to use that information. And if they, for example, are resident in the country that are not taxing all the income or taxing basically only based on territorial taxation, then that really the information received from other countries where the bank accounts are opened, like in Switzerland or in Great Britain, it would not matter much. The question is more for example, if you remain in a Ukrainian or then a Russian tax resident, where the tax authorities can really go beyond even their powers with the information they receive. But again, you have to become interesting to them so that they could launch the tax audit and somehow use that information, because the amount of information received during CRS is huge, and I think the resources of the tax authorities are not that large to really use that information to process it even.
Okay. There is one more question. Alina, what is your limitation? I remember you told that you are quite restricted in terms of timing. So would it be fair to take one?
Yeah, yes. Well, around 3 minutes, because I need to run to sing lullabies.
Okay, good. Oh, well, very much appreciate that you're here and we exhausted all the time. Well, a question of Niels Rovers. Does China provide information on request? Specifically for Niels, this is the list of activated information ties, and China even provides information in automatic regime. So on the request, it's the previous level. I'm pretty much sure that if China shares information automatically, or in particular with the Netherlands, it should provide information on request as well. And there was a question from Gauhar, but Gauhar for some reason did not proceed. Anyway, Alina, then thank you very much. If you do not mind, I will distribute your contact details if there will be some follow-up questions. Sure. And next week, we are going to have a presentation of Ikhwan Suhardi, another ITC alumni from Indonesia, and he will share with us his views on recent developments in Southeast Asian region. Very exciting. Alina, thank you once more. Excellent presentation. So
thank you for inviting me. It was a pleasure.
Thank you, and thanks to all for participation. Thanks. Bye.
Thanks. Bye bye.